Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron, everyone. Thanks for joining us today. I'm joined once again, by attorney Zac Morgan. How's it going, Zac?
I'm good, Aaron, and good. Almost Merry Christmas to your many viewers.
Yes, Merry Christmas Eve. So, everyone, we're here talking about the hearing that's been scheduled in the trafficking lawsuit against David Miscavige. After years of dodging process servers, the court is on the verge, it looks like, of ruling that he has been served. This particular case has only been going on for about 8 months, but for other civil cases, he's been hiding from process servers for years. So this is kind of a big deal. Zac, I wanted you to help me and the viewers understand a bit. So we know that this case is being heard by Thomas Barber, federal district judge. Is that the right way to describe his position?
It is, yes.
And yet this particular hearing has been subbed out to a magistrate judge, Julie S. Sneed. What is a magistrate judge?
So in order to understand what a magistrate judge is, let's make sure we understand what a district judge is. And a district court judge is a judge that has been nominated to the bench by the President of the United States and confirmed by the Senate. These confirmations occur all the time. The most famous of these are, of course, when a new justice of the Supreme Court has all of their hearings, most recently Ketanji Brown Jackson, and before that, Amy Coney Barrett. That same process applies to district court judges. It's just a much less high-profile process, and there's hundreds of them all over the country. That's a life tenure position. They have life tenure, which means unless they misbehave in office, such as commit fraud or commit a crime of violence or something, they're there until they retire or die. They're not subject to election. However, because of their caseload and how busy they are, the court system has developed what are called magistrate judges. Magistrate judges are not life tenure. It is an open application process where anybody who wants to be a magistrate judge applies when there's an opening. The district court judges of that federal district review all of those applications. A lot of times there's attorneys who practice in that court who are also on that selection committee. They are then hired, and I think it's a 7-year term. They do not have full jurisdiction. So they sort of serve as, if you think of like in a criminal court, you would go before, say, an associate judge or a magistrate or a special judge. Who has limited jurisdiction to hear procedural matters, but the jury trial is before the full district judge, same kind of thing.
I see. So you don't already have to be sitting as some other type of judge to throw your hat into the ring as a magistrate judge. You can just be a practicing attorney and apply for that position.
Absolutely. And in fact, that's how most people do it. In fact, one of the states I'm admitted to practice in Colorado, I'm admitted before the federal district, the United States District Court for the District of Colorado. And they recently hired 3 new magistrates who one of them is a prosecuting attorney out of the U.S. Attorney's Office. And one of them was a government lawyer for the city and county of Denver. And another one came out of private practice as a trial attorney out of a big, we'll call ivory tower firm.
Interesting. So the fact that this hearing has been subbed out to a magistrate judge, there's nothing that should be inferred from that, right?
No. So district court judges will often, in fact, almost as a matter of routine practice, anytime there's a dispute that is not dispositive. And when I say the term dispositive, I mean it is not a jury trial. So, for example, a motion to dismiss or a motion to quash a subpoena, a motion to join a party or to dismiss a party, a motion for summary judgment, all those kinds of things, even discovery disputes. You tell the district judge, we have a disagreement, we have a dispute, we need resolved, and the district judge says, I'm going to assign this to the magistrate, who will then hear this, and the magistrate will hear the evidence, take the arguments, read the briefs, and will write a memorandum order, a memorandum opinion that the parties are bound by, but the parties can immediately appeal that to the district judge, the full district judge, and the district judge can say, I agree with the magistrate, I disagree with the magistrate, or the magistrate got part of it right, part of it wrong, and can adopt and modify the magistrate's memo to make it the effective law as the district court seems fit.
That makes sense. Couldn't someone say, though, that the magistrate judge is at a bit of a disadvantage, not being as familiar with the facts in the case as the district judge, who's already seen all the pleadings and the motions and all that kind of stuff?
So one would make the argument, but the reality of it is any matter that goes before the magistrate will brief themselves and read all of the relevant pleadings up to that point. So the fact that the various Scientology entities have accepted service doesn't really matter in this motion. Right.
Right.
So they don't really care that the various Scientology entities have accepted service. All they care about is this is the David Miscavige issue. So they'll read the pleadings to become familiar with them, but they're only going to read the ones that affect their decision that they have to make on this case.
That makes sense. When a magistrate judge or anyone other than the federal district judge is having to bone up on a case that they're stepping in on to help with a hearing or whatever, are they only reading everything that's in the public record, or are there any? Does the federal judge keep any notes for himself, his thoughts, his leanings, or whatever that are shared with the magistrate judge or anything like that?
Generally not. So when if the judge has working notes or maybe an outline or something, we would call that work product, and that's for lack of a better term, that's cherished by the judge who worked up that work product. They certainly are free to share it with the magistrate if they choose to, but generally speaking, they will say, all right, Mr. or Madam Magistrate, you're going to resolve this. And the magistrate basically views it with clean eyes and reaches the conclusions on their own.
Interesting. So when this hearing was first announced, like a couple days ago, it was announced that it was going to be held over Zoom. I did a video where I mentioned, oh, that's great because we could stream it. I then found out it's highly against the rules to stream or record any one of these Zoom type meetings. And I hope it's not because of me, but I just found out this evening that this thing is no longer going to be held over Zoom. It's actually going to be held in chambers at the courthouse. Let me pull up the email. I'm not going to share it with everyone, but I'm just going to read this. The hearing will be in the chambers at the courthouse, same day, same time, no longer via Zoom. Motion hearing set for January 20th, 2 p.m., Tampa courtroom 11A, before Magistrate Judge Julie S. Sneed. Joseph Terry and Crystal Durham are newly added attorneys for David Miscavige, along with previously entered Bill Schifino Jr. The latest pending motion is just asking the court to allow Miscavige's opposition brief to have 5 more pages than the court's rules allow, which the court's rules allow for 20 pages. So we will certainly have access to the brief before the hearing. I guess I have a couple questions about this.
Sure.
Why is it that in a federal courthouse or a federal case like this, there's no electronic devices, there's no cameras, there's no streaming? Why is that?
That's a good question. It's probably for lack of a better term, well, we've always done it that way. The law loves to use phrases like we've always done it that way. Doesn't make it better. And ultimately, it's at the discretion of the presiding judge. And the presiding judge is generally the judge who's been on that particular district court bench the longest. So whoever the presiding judge in Tampa is the judge who's been there the longest. That's how they generally take the title of presiding judge. But the reality of it is, if you allow a recording or cameras or something, it becomes a nightmare in how you regulate that. So every time, let's say, for example, Law and Crime Network, they've been showing the trial of Kerry Lake in Arizona. They showed the Alex Jones trials. The court prepared several orders in all of those, what the camera can look at, what it can't. And then there's the issue of having to bring in a whole extra set of microphones, and you've got all the production staff that are involved in all that. And so just logistically, the federal court said, listen, this is not a dog and pony show. It's fine if state courts want to do it. We're just not going to do it here. And the reason that there's an outright ban, I think you even mentioned Mark Bunker, when he went to the last hearing, they made him take his smartwatch back to his car. That's super common because the court doesn't want information coming out of the courtroom that the judge has not authorized to leave.
Interesting. And yet attorneys can be in there with their phones and everything. Reporters can be in there. They can't record what's happening, but they can certainly report on everything that's happening. It just seems so weird to me, but maybe it is just an aspect of, well, that's just the way it's always been done. Like anybody can, like, that's the thing. Anybody can go and witness the entire thing, and yet they want to regulate how much of that information makes it out of the courtroom. Like, I just don't.
Well, but it's also the manner in which it makes it out. They don't want, for example, a guy in the back row, sort of like Mark had the other day, the guy with the pin camera, right? They don't want somebody illegally trying to record information. But also, and I can tell you this from firsthand experience, you get a bunch of reporters on the back row with their laptops pounding away on keyboards. It's pretty distracting to the judge who's trying to listen, to the witnesses who are trying to listen, to the attorneys who are doing the examination, for the court reporter who's transcribing it all, to the point that if you, the little machines they use, the little stenography machines, the keys are actually dampened. They could be pounding away on those keys and you're never going to hear it. It's almost silent when they transcribe, as opposed to the laptop keyboard that I'm sitting on, bangs around. Everybody in the house can hear it when I'm out trying to pound out a motion or something.
That does make sense. That actually does make sense, because these courtrooms aren't exactly big. Actually, from the sounds of it, the federal courtroom here in Tampa is much bigger than what it sounds like Danny Masterson's case was being held in. Okay, so what do you make of the fact that this thing was going to be held over Zoom, and now it's not? They canceled that. They're just going to hold it in the chambers. Why would they be holding it in chambers where nobody can observe this thing instead of in where it can be observed?
You know, there's no direct answer as to why it's no longer on Zoom, but I think if there was, you know, word got it, because all those orders are public. I mean, you had a source send them to you. You had me look at it and say, hey, what do you think of this? Those orders are public. They're part of the public record. And in fact, anybody can go to pacer.gov, pacer.gov, and if you're willing to pay the money to download it, you can look up any pleading in any federal case anywhere in the country right now.
Yeah.
And so I think it probably was a mix, and this is just sheer speculation, but it's becoming a higher profile case. You are not the only person to probably reach out, if you did, to try and inquire, how can I attend this hearing? And there may also be some security protocol that is being discussed. For example, if there may be argument about, you know, the type of security protocol David Miscavige has, or the type of security that's in place at the various Scientology facilities. And that is protected information. Just as a business, the government contractor, for example, may show up and say, hey, we're involved in this lawsuit, but we want to have a discussion about, you know, the security is important, but we don't want the world to know where our security cameras are, and, you know, that we have trespass access devices and things like that. So that there's a variety of reasons, I think.
Right. So not only did I, you know, send in my little request on the website to get access to the Zoom meeting, but I did tweet out a link to the form and encourage everyone else to submit similar requests. Do you think that's why this thing has been canceled?
Oh, you know, maybe indirectly. It's hard to know for sure. The other thing that is very possible, and I would not be surprised if one of the parties has requested that this hearing be transcribed. And a court reporter is going to be back there. If somebody has asked for it to be transcribed and paid the transcription fee, the court reporter will transcribe all this, write it all down, and then those transcripts will be made available. You just have to pay for them. But it's like everything else. It's a recorded legal proceeding. And even if there's not a court reporter, most of them will still audio record it for the purposes of preserving the record for appeal.
So unless someone has specifically requested it, there would not just automatically be a transcript of this hearing generated?
No, and that's why I say, as a matter of due course, in federal court, most of them are going to be audio recorded and just stored on an SD card somewhere. In the event, because a party can come back later and say, Judge, we'd like a transcript made so we can appeal it. And in that case, the court reporter would take the audio, put the headphones in, and type it out. But in order to get a court reporter, you actually have to pay a court reporter fee. That gives you access to the court reporter and puts them in that courtroom on that day. And then if you want the transcript, there's an additional fee to have the transcript presented.
Interesting. So the fact that this hearing is being held in chambers, I'm assuming that means no members of the public are allowed to attend.
Correct. It would be, I don't know if it's considered a closed hearing specifically or not, but the public would be treating it like a closed hearing. There won't be any media there. The media could easily be in the courtroom, of course, but in chambers is the fancy word for the judge's office. And when you get back behind the courtroom, there's a variety of offices. There's sort of the entryway. There'll be offices for the clerks. The judge will have chambers. There may be a restroom facility, probably a conference room, and then a jury deliberation room. All of those various ante rooms make up what we call chambers. But this specifically would probably be in the judge's office.
I just don't know what to make of the fact that, you know, The last hearing in this case was held in a courtroom with, I don't know, 20 or 30 or 40 people watching. And now it's being held in an office that no one's allowed to watch what's going on. And we'll be lucky if we even get a transcript of it. That's pretty disappointing.
While I don't disagree, there will, however, be a written order. Even if the judge rules in her office and says, yeah, motion granted, motion denied, there will still be a written order because it's a memo order that goes to the district court judge. And the district court judge needs to, when the district court judge determines whether or not the magistrate got it right or wrong, they're going to look at the analysis, and the court is going to say, here's what the law says, here's the analysis that I did, and here's the decision that I reached, and that the analysis is going to be the important part of that, and that will all be written in an order.
Right. We wouldn't expect to see something like that until weeks after the hearing, right?
I would presume probably, you know, the judge is, before the hearing, will have an idea of which direction she's leaning, but the parties won't know which direction she's leaning, and she will have, of course, read all the briefs and be up to date and up to speed on the law of the case. And then, you know, she may say, yep, the argument has reinforced my decision, or no, I've changed my mind, or I'm going to go back and I'm not sure what I'm going to do. I need to delve deeper and look at what other courts are how other courts are treating this.
That was going to be my next question, is that in something that does seem to be relatively straightforward. I mean, I know that's all relative. Would you expect the judge to actually tell the participants at this hearing what her decision is? Or could it be one of those things where it's like, okay, great, I'll let you know in a couple of weeks?
You know, it's a 50-50 call. It's a flip of a coin. There's no way to know for sure. If the judge is confident and the judge has already made up her mind, yeah, I'm going to grant the motion in order to follow. In that case, what we call those are minute orders. And the clerk or the judge will type out a 1 or 2 sentence minute order and post it to the court file, because it's all electronic now. Post it to the court file, and then there will be a full order that follows after the judge has the opportunity to write out the full analysis. So if the judge is convinced of immediately, yep, yes or no, they'll go ahead and issue that order as a minute order, and then have a full order to follow. Or they may say, all right, argument received. I'm going to go back and deliberate, and then I'll issue an order when I'm ready.
Right. If the judge gives her decision right there in the meeting, but hasn't released a statement to the public, are the plaintiff's attorneys allowed to make any public comment about it?
As long as there's not a gag order in place, any of the attorneys can say something about it. The gag order basically says you're not allowed to talk to the public, but that order is a public order.
Yeah,
even if
no
it's given
order
from the bench. Yeah, as long as there's no gag order and the magistrate says motion granted, I'll prepare an order, and then the parties are dismissed. Please go away. They have it. They have every right to come out and say, hey, the judge has granted the motion, and we're excited that Miscavige has been served, and we're ready to proceed with litigation.
That would be cool. Okay, so, and it does sound like, let me just double check this email that I got. What do you think about Miscavige now hiring 2 extra lawyers to represent him in this one issue? What are your thoughts?
So a couple of things. I don't know exactly what firm those other 2 are from, but it's a very strong likelihood that they're with the primary attorney's firm, and that they're simply associates. For example, when I was an associate, well, I'm still an associate, but as an associate, when I enter a case, I enter it, and then I also enter my partner.
I see.
As the associate, I'm doing the handling of the file, but my partner is, of course, by entering, he's also going to receive all the emails. He's also going to receive all the pleadings, all the correspondence he'll be included on. And it could also be that they are, for lack of a better term, specialty attorneys. Right, a higher profile, well-respected member of the bar is the primary attorney, but either in his firm or he went out and found somebody who is a specialist in civil procedure, or somebody, maybe he's a very good orator and he makes fantastic oral argument, but he may not be a great writer. That's okay. Maybe he went out and hired really good brief writers. Maybe it's vice versa. He's a very good brief writer, but he's not the best at arguing live. So maybe he went and retained an attorney who's got really good oral advocacy skills. It's just making sure you have all the resources you need to put on the best case.
Very interesting. Okay, so this is the thing from the email I wanted to just make sure I was understanding it correctly. The latest pending motion is just asking the court to allow Miscavige's opposition brief to have 5 more pages than the court's rules allow. So we will certainly have access to that brief before the hearing. What is it about what I just read that makes it certain that we will have access to the brief before the hearing?
Well, there's a deadline. The briefs have to be filed so many days prior to the hearing, and they're public
Okay.
records. So as long as you're willing to
Oh,
pay the money and get it off a Pacer, you can pull it off a Pacer. The
I see.
specific note there says that the local rules there in Tampa state that a response brief, which is what this is limited to 20 pages. If you want to go longer than 20 pages, and that includes the header and the footer, so the signature block and the service certificate in most jurisdictions. If you want to go longer than 20 pages, you have to literally write a motion to the judge. Comes now, non-party David Miscavige by and through his undersigned counsel and hereby request an additional 5 pages, and then you have to show why. We've written 20 pages. This is a complicated issue for the following reasons. The additional 5 pages are needed. Most of the time, judges will grant those as a matter of due course, sort of rubber stamp it. Yeah, that's fine, no problem. But if you just say, I need 5 pages more, thank you, that's not enough. You have to show the judge that you have a legitimate reason for needing 5 pages. That does not move the deadline in which it's due. It just allows them more pages to write.
Interesting. If Pacer charges to download this stuff, is it against the rules to post that information to the internet?
No,
that you know of?
it's public document. No, the fee that you're charged to download from Pacer is basically to pay the government back the cost of operating the electronic storage media.
Okay.
It's no different than
David.
David, we'll get to just a second. It's no different than if you file an open records request and then you have to pay the copy fee and then you post it on Twitter or Facebook. You can do that. It's a public record. You just had to pay the fee.
Right. I wondered last night if telling people to inquire about the hearing would torpedo the hearing. I got to tell you, it did not even occur to me that could be a possibility. And let's be honest, I don't know that that's what happened, but it seems so convenient to do something over Zoom that I'm having a hard time reconciling why they would be like, oh yeah, no, cancel that super convenient thing that we were talking about. And let's change it to a venue where nobody can even watch the damn thing. Perhaps the fact that I said I would like live stream it. I was literally thinking last night, once I found out that was highly against the rules, I was like, oh yeah, I would obviously never do that, because if I did, Scientology's attorneys would make sure that I was barred from attending any of the hearings in the courtroom for sure. That crossed my mind, but I didn't know it was against the rules when I said I wanted to do it.
Right.
So anyway, nobody knows. Okay. Well, those were all my questions. Anything about all this that you think is interesting we haven't commented on?
I was going to go back and see the message that I sent the other day to make sure that there were a couple of things I said, hey, we should talk about this. Let's see.
I can pull it up too.
Yeah, here it is. Let's see. Yeah. So normally members of the public should be able to get access to it, but of course it's now gone in camera. When I say in camera, it's the Latin phrase for in chambers, in camera. It's the same thing. And then the other thing that you and I had talked about, and I had gotten some questions in the chat about this. I don't remember what it was now, but you and I had talked about that after the last broadcast. But I'll go back and look and see what was in those comments, and we can do another video on those.
Yeah. Okay, cool. Well, thanks for joining us, everybody, on this fine Christmas Eve. What's the temperature where you're at, by the way?
About 6 Fahrenheit, wind chill in the low negative teens.
Is that right? I think, we were actually quite warm this morning, but it's cooling off pretty quickly right now. But there's no way we're even in the high 40s, I don't think, down here in Clearwater, Florida. So all right. Well, I'm glad we at least got a chance to talk about this. And if anything else comes to mind, of course, shoot me a message.
Absolutely,
all right, everyone. Thanks for joining us. Have a wonderful evening.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click wow.